The Secretaries of Defense, Interior, Agriculture, Commerce, Housing and Urban Development, Transportation, Energy, Homeland Security, the Administrator of the Environmental Protection Agency, the Chairman of CEQ, and the heads of any other relevant agency shall undertake all available efforts to eliminate all delays within their respective permitting processes, including through, but not limited to, the use of general permitting and permit by rule. For any project an agency head deems essential for the nation's economy or national security, agents shall use all possible authorities, including emergency authorities, to expedite the adjudication of federal permits. Agencies shall work closely with project sponsors to realize the ultimate construction or development of permitted projects. E. The director of the NEC and the director of the Office of Legislative Affairs shall jointly prepare recommendations to Congress, which shall I. Facilitate the permitting and construction of interstate energy transportation and other critical energy infrastructure, including but not limited to pipelines, particularly in regions of the nation that have lacked such development in recent years, and 2. Provide greater certainty in the federal permitting process, including but not limited to streamlining the judicial review of the application of NEPA. Section 6. Prioritizing accuracy in environmental analysis. A. In all federal permitting educations or regulatory processes, all agencies shall adhere to only the relevant legislated requirements for environmental considerations, and any considerations beyond these requirements are eliminated. In fulfilling all such requirements, agencies shall strictly use the most robust methodologies of assessment at their disposal and shall not use methodologies that are arbitrary or ideologically motivated. B. The Interagency Working Group on the Social Cost of Greenhouse Gases, which was established pursuant to Executive Order 13990, is hereby disbanded, and any guidance, instruction, recommendation, or document issued by the IWG is withdrawn as no longer representative of governmental policy, including 1. The Presidential Memorandum of January 27, 2021, Restoring Trust in Government Through Scientific Integrity and Evidence-Based Policymaking. 2. The Report of the Greenhouse Gas Monitoring and Measurement Interagency Working Group of November 2023, National Strategy to Advance an Integrated U.S. Greenhouse Gas Measurement, Monitoring, and Information System. 3. The Technical Support Document of February 2021, Social Cost of Carbon, Methane, and Nitrous Oxide Interim Estimates under Executive Order 13990, and 4. Estimates of the social cost of greenhouse gases, including the estimates for the social cost of carbon, the social cost of methane, or the social cost of nitrous oxide based in whole or in part on the IWG's work or guidance. C. The calculation of the social cost of carbon is marked by logical deficiencies, a poor basis in empirical science, politicization, and the absence of a foundation in legislation. Its abuse arbitrarily slows regulatory decisions and, by rendering the United States economy internationally uncompetitive, it encourages a greater human impact on the environment by affording less efficient foreign energy producers a greater share of the global energy and natural resource market. Consequently, within 60 days of the date of this order, the administrator of the EPA shall issue guidance to address the harmful and detrimental inadequacies, including consideration of eliminating the social cost of carbon calculation from any federal permitting or regulatory decision. D. Prior to the guidance issued pursuant to such subsection C of this section, agencies shall ensure estimates to assess the value of changes in greenhouse gas emissions resulting from agency actions, including with respect to the consideration of domestic versus international efforts, and evaluating appropriate discount rates, are, to the extent permitted by law, consistent with the guidance contained in OMB Circular A-4 of September 17, 2003. E. Furthermore, the head of each agency shall, as appropriate and consistent with applicable law, initiate a process to make such changes to any rule, regulation, policy, or action as may be necessary to ensure consistency with the regulatory analysis. F. Within 30 days of the date of this order, the administrator of the EPA, in collaboration with the heads of any other relevant agencies, shall submit joint recommendations to the director of OMB on the legality and continuing applicability of the administrator's findings. Endangerment and cause or contribute findings for greenhouse gases under Section 202A of the Clean Air Act, Final Rule 74, FR 66496, December 15th, 2009. Section 7, terminating the Green New Deal. A. All agencies shall immediately pause the disbursement of funds appropriated through the All agencies shall immediately pause the disbursement of funds appropriated through the Inflation Reduction Act of 2022 or the Infrastructure Investment and Jobs Act, including but not limited to funds for electric vehicle charging stations made available through the National Electric Vehicle Infrastructure Formula Program and the Charging and Fueling Infrastructure Discretionary Grant Program, and shall review their processes, policies, and programs for issuing grants, loans, contracts, or any other financial disbursements of such appropriated funds for consistency with the law and the policy outlined in Section 2 of this order. Within 90 days of the date of this order, all agency heads shall submit a report to the Director of the NEC and Director of OMB that details the findings of this review, including recommendations to enhance their alignment with the policy set forth in Section 2. No funds identified in this subsection A shall be dispersed or by a given agency until the Director of OMB and Assistant to the President for Economic Policy have determined that such disbursements are consistent with any review recommendations they have chosen to adopt. B. When procuring goods and services, making decisions about leases, and making other arrangements that result in disbursements of federal funds, agencies shall prioritize cost effectiveness, American workers and businesses, and the sensible use of taxpayer money to the greatest extent. The Director of OMB shall finalize and circulate guidelines to further implement this subsection. C. All agencies shall assess whether enforcement discretion of authorities and regulations can be utilized to advance the policy outlined in Section 2 of this order. Within 30 days of the date of this order, each agency shall submit a report to the Director of OMB identifying any such instances. Section 8. Protecting America's national security. A. The Secretary of Energy is directed restart reviews of applications for approvals of liquefied natural gas export projects as expeditiously as possible, consistent with applicable law. In assessing the public interest to be advanced by any particular application, the Secretary of Energy shall consider the economic and employment impacts to the United States and the impacts to the security of allies and partners that would result from granting the application. B. With respect to any proposed deep water port for the export of liquefied natural gas, for which a favorable record of decision has previously been issued pursuant to the Deep Water Port Act of 1974, the Administrator of the Maritime Administration shall, within 30 days of the date of this order, and consistent with applicable law, determine whether any refinements to the project proposed subsequent to the ROD are likely to result in adverse environmental consequences that substantially differ from those associated with the originally evaluated project, so as to present a seriously different picture of the foreseeable adverse environmental consequences. In making this determination, MARAD shall qualitatively assess any difference in adverse environmental consequences between the project with and without the proposed refinements, including any potential consequences not addressed in the final environmental impact statement, which shall be considered adequate under NEPA, notwithstanding any revisions to NEPA that may have been enacted following the final EIS. MARAD shall submit this determination together with a detailed justification to the Secretary of Transportation and to the President. C. Pursuant to subsection B of this section, If MARAD determines that such refinements are not likely to result in seriously different consequences, it shall include in that determination a description of the refinements to supplement and update the ROD, if necessary, and then no later than 30 additional days, he shall issue a DWPA license. If MARAD determines, with concurrence from the Secretary of Transportation, that such proposed refinements are likely to result in seriously different consequences, it shall, within 60 days after submitting such determination, issue an environmental assessment examining such consequences and, with respect to all other environmental consequences not changed due to project refinements, shall reaffirm the conclusions of the final EIS. Within 30 days after issuing the EA, MARAD shall issue an addendum to the ROD, if necessary, and shall, within 30 additional days, issue a DWPA license consistent with the ROD. Section 9. Restoring America's Mineral Dominance. A. The Secretary of the Interior, Secretary of Agriculture, Administrator of the EPA, Chairman of CEQ, and the heads of any other relevant agencies, as appropriate, shall identify all agency actions that impose undue burdens on the domestic mining and processing of non-fuel minerals, and undertake steps to revive or rescind such actions. B. The Secretaries of the Interior and Agriculture shall reassess any public lands withdrawals for a potential revision. C. The Secretary of the Interior shall instruct the Director of the U.S. Geological Survey to consider updating the survey's list of critical minerals, including for the potential of including uranium. D. The Secretary of the Interior shall prioritize efforts to accelerate the ongoing detailed geologic mapping of the United States with a focus on locating previously unknown deposits of critical minerals. E. The Secretary of Energy shall ensure that critical mineral projects, including the processing of critical minerals, receive consideration for federal support contingent on the availability of appropriated funds. F. The United States Trade Representative shall assess whether exploitative practices and state-assisted mineral projects are abroad, are unlawful, or unduly burden or restrict United States commerce. G. The Secretary of Commerce shall assess the national security implications of the nation's mineral reliance and the potential for trade action. H. The Secretary of Homeland Security shall assess the quantity and inflow of minerals that are likely the product of forced labor into the United States and whether such inflows pose a threat to national security and, within 90 days of the date of this order, shall provide this assessment to the Director of the NEC. I. The Secretary of Defense shall consider the needs of the United States in supplying and maintaining the national defense stockpile, review the legal authorities and obligations in managing the national defense stockpile, and take all appropriate steps to ensure that the national defense stockpile will provide a robust supply of critical materials in event of future shortfall. J. Within 60 days of the date of this order, the Secretary of State, Secretary of Commerce, Secretary of Labor, the United States Trade Representative, and the heads of any other relevant agencies shall submit a report to the Assistant to the President for Economic Policy that includes policy recommendations to enhance the competitiveness of American mining and refining companies in other mineral-wealthy nations. K. The Secretary of State shall consider opportunities to advance the mining and processing of minerals within the United States through the Quadrilateral Security Dialogue. And then we have Section 10, General Provisions. And that was Unleashing American Energy. We are at Realigning the United States Refugee Admissions Program. By the authority vested in me as President by the Constitution and the laws of the United States of America, including the Immigration and Nationality Act, 8 U.S.C. 1101, and the following, and Section 301 of Title III, United States Code, it is hereby ordered. Section 1, Purpose. Over the last 4 years, the United States has been inundated with record levels of migration, including through the U.S. Refugee Admissions Program. Cities and small towns alike, from Charleroi, Pennsylvania, and Springfield, Ohio, to Whitewater, Wisconsin, has seen significant influxes of migrants. Even major urban centers such as New York City, Chicago, and Denver have sought federal aid to manage the burden of new arrivals. Some jurisdictions, like New York and Massachusetts, have even recently declared states of emergency because of increased migration. The United States lacks the ability to absorb large numbers of migrants, and in particular, refugees, into its communities in a manner that does not compromise the availability of resources for Americans, that protects their safety and security, and that ensures the appropriate assimilation of refugees. This order suspends the USRAP until such time as the further entry into the United States of refugees aligns with the interests of the United States. Section 2, Policy. It is the policy of the United States to ensure that public safety and national security are paramount considerations in the administration of the USRAP, and to admit only those refugees who can fully and appropriately assimilate into the United States, and to ensure that the United States preserves taxpayer resources for its citizens. It is also the policy of the United States that, to the extent permitted by law and as practicable, state and local jurisdictions be granted a role in the process of determining the placement or settlement in their jurisdictions of aliens eligible to be permitted to the United States as refugees. Section 3. Realignment of the U.S. Refugee Admissions Program. A. I hereby proclaim, pursuant to Sections 212F and 215A of the INA 8 USC 1182F and 1185A, that entry into the United States of refugees under the USRAP would be detrimental to the interest of the United States. I therefore direct that entry into the United States of refugees under the USRAP be suspended, subject to the exceptions set forth in subsection C of this section, until a finding is made in accordance with Section 4 of this order. This suspension shall take effect at 12:01 a.m. Eastern Standard Time on January 27, 2025. B. The Secretary of Homeland Security shall suspend decisions on applications for refugee status until a finding is made in accordance with Section 4 of this order. C. Notwithstanding the suspension of the USRAP imposed pursuant to subsections A and B of this section, the Secretary of State and the Secretary of Homeland Security may jointly determine to admit aliens to the United States as refugees on a case-by-case basis in their discretion, but only so long as they determine that the entry of such aliens as refugees is in the national interest and does not pose a threat to the security or welfare of the United States. D. The Secretary of Homeland Security, in consultation with the Attorney General, shall examine existing law to determine the extent to which, consistent with applicable law, state and local jurisdictions may have greater involvement in the process of determining the placement or resettlement of refugees in their jurisdictions, and shall devise a proposal to lawfully promote such involvement. In all cases, the Secretary of State and the Secretary of Health and Human Services shall ensure that the state and local consultation requirements in 8 U.S.C. 1522A2 are carried out with respect to all refugees admitted to the United States. Section 4. Resumption of the U.S. Refugee Admissions Program. Within 90 days of this order, the Secretary of Homeland Security, in consultation with the Secretary of State, shall submit a report to the President through the Homeland Security Advisor regarding whether resumption of entry of refugees into the United States under the USRAP would be in the interests of the United States. In light of the policies outlined in Section 2 of this order, the Secretary of Homeland Security, in consultation with the Secretary of State, shall submit further reports every 90 days thereafter until I determine that resumption of the USRAP is in the interest of the United States. Section 5. Revocation. Executive Order 14013 of February 4th, 2021, rebuilding and enhancing programs to resettle refugees and planning for the impact of climate change on migration, is hereby revoked. Section 6. Severability. If any provision of this order or the application of any provision to any person or circumstance is held to be invalid, the remainder of this order and the application of its other provisions to any other persons or circumstances shall not be affected thereby. And then we have general provisions, and that was realigning the United States Refugee Admissions Program. Next, we have protecting the meaning and value of American citizenship. By the authority vested in me as President by the Constitution and the laws of the United States of America, it is hereby ordered. Section 1. Purpose. The privilege of United States citizenship is a priceless and profound gift. The 14th Amendment states, all persons born or naturalized in the United States and subject to the jurisdiction thereof are citizens of the United States and of the state wherein they reside. That provision rightly repudiated the Supreme Court of the United States' shameful decision in Dred Scott v. Stanford, which misinterpreted the Constitution as permanently excluding people of African descent from eligibility for United States citizenship solely based on their race. But the 14th Amendment has never been Wait, hold on. Okay, got it. Okay. Understood.
Not understood.
Okay, so basically what this is saying is the 14th Amendment states that any person born in... It's basically birthright citizenship is what the 14th Amendment is. You're born here, you're a citizen, which repudiates a decision made by the Supreme Court in Dred Scott v. Stanford in 1857, which misinterpreted the Constitution as permanently excluding people of African descent from eligibility for United States citizenship based on race.
Okay.
So they're not saying that African Americans can't be here. That they're saying...
I thought we were about to get the... I thought it was about to throw the hardest, not even curveball, but like...
Yeah, that's why I had to stop
I know,
and make sure.
that's like interesting. Like, what do you mean just a whole entire huge part of the population that is legal to be here just is immediately just not a citizen anymore? Well, I guess not immediately, but like, you know what I mean.
Yeah.
Like, that was kind of...
No, they're basically trying to reinterpret the 14th Amendment as birthright citizenship isn't necessarily the case. But the 14th Amendment has never been interpreted to extend citizenship universally to everyone born within the United States. The 14th Amendment has always excluded from birthright citizenship persons who are born in the United States but not subject to the jurisdiction thereof. Consistent with this understanding, the Congress has further specified through legislation that a person born in the United States and subject to the jurisdiction thereof is a national and citizen of the United States at birth, generally mirroring the 14th Amendment's text. Among the categories of individuals born in the United States and not subject to the jurisdiction thereof, the privilege of United States citizenship does not automatically extend to persons born in the United States. 1. When that person's mother was unlawfully present in the United States and the father was not a United States citizen or lawful permanent resident at the time of said person's birth. Or 2. When that person's mother's presence in the United States at the same time of said person's birth was lawful but temporary, such as, but not limited to, visiting the United States under the auspices of the Visa Waiver Program or visiting on a student, work, or tourist visa, and the father was not a United States citizen or lawful permanent resident at the time of said person's birth.
So you can't, like, just be visiting the country and have your kid here and have them be a citizen?
Yeah, you can't be visiting, you can't be on a work visa, you can't be any of that. You yourself would have to be a citizen in order to give birth to someone who would gain citizenship. Section 2, Policy. It is the policy of the United States that no department or agency of the United States government shall issue documents recognizing United States citizenship or accept documents issued by state, local, or other governments or authorities purporting to recognize United States citizenships to persons, 1, when that person's mother was unlawfully present in the United States and the person's father was not a United States citizen or lawful permanent resident at the time of said person's birth, or 2, when that person's mother's presence in the United States was lawful but temporary and the person's father was not a United States citizen or lawful permanent resident at the time of said person's birth. Subsection A of this section shall apply only to persons who are born within the United States after 30 days from the date of this order. Well, that's nice. C. Nothing in this order shall be construed to affect the entitlement of other individuals, including children of lawful permanent residents, to obtain documentation of their United States citizenship. Section 3. Enforcement. A. The Secretary of State, the Attorney General, the Secretary of Homeland Security, and the Commissioner of Social Security shall take all appropriate measures to ensure that the regulations and policies of the respective departments and agencies are consistent with this order, and that no officers, employees, or agents of the respective departments and agencies act or forbear from acting in any manner inconsistent with this order. B. The heads of all executive departments and agencies shall issue public guidance within 30 days of the date of this order regarding this order's implementation with respect to their operations and activities. Section 4. Definitions. As used in this order. Mother means the immediate female biological progenitor. B. Father means the immediate male biological progenitor. And Section 5. General provisions. All right, and that was protecting the meaning and value of American citizenship.